The first and the foremost is the litigant himself. The litigant, as I said, should not set up bogus claim and cases. He must make an endeavor to settle the case before the process is started. So the heavy load is on the litigant to decide as to whether they really want to go into litigation, because this will really help them in reducing the cost of the litigation and also help in the arrears which are otherwise piling up. The second is our fraternity, which has a very big role to play. We must not encourage, as I was saying, bogus litigation or encourage the litigant to fight litigation, and must not take unnecessary adjournment, and must see that the result must come very fast in a litigation, because the stakeholders, namely the litigant, would lose confidence in the system if he finds that a claimant, I'm not talking about the defendant, because it's always a hurrah hurrah time for a defendant if the litigation is stressed, but a claimant will lose confidence in a system if it is not going to give him the result in the shortest span of time. Added to this is a very sensitive issue. I know most of you would be very annoyed with me for speaking this. One of the factor responsible for the high cost is the high fees of the lawyers. There was a move few years back in the Supreme Court that we must put a cap on the litigation fees. Unfortunately, things did not move because there are certain vested interests. They wouldn't allow this to happen. But we have to look into the larger interest of the society. Here I expect a bigger role by the Bar Council, where they must mandate that this should be the cap on the litigation or the fees of any counsel, or for that matter, or the total expenditure on litigation. And anybody violating will incur the wrath, whatever is under the Bar Council rules and act. The two more factors, sir, I'll just wind up. I shouldn't take more than 3 minutes. The other is, at the instance of the court, a simple procedure adopted by the court, time to adjudicate cases would come a long way in helping or reducing the cost and also for speedy justice. The last stakeholders in the litigation is the government. Government as a litigant or government as an agency or as a body which has the responsibility of either coming out with law through its various legislation or through its various decision. One thing which is foremost is, very rightly yesterday Mr. Rohatgi said, because I had witnessed being a tax lawyer in the Supreme Court, he said he has been able to reduce most of the tax litigation. I'll just seek the chairman's permission to just say this instance, because it's absolutely been troubling me for the last so many years. Just give me 20 seconds, sir, I'll then wind up. We do file a lot of litigation on the tax side from the government side, concurrent finding, but still we want to file the litigation. Government files the litigation. One of the deputy commissioner litigation came to my chamber. I was so furious because that time the bench which was hearing the tax was Justice Kapadia, was always discouraging the government from filing all sort of litigation. I was so furious with the gentleman. I told him, why did you file this appeal? It's your affidavit which is there. Why did you file this appeal? And the judge is going to be furious. And what he said to me was absolutely, it has troubled me for the last so many years, which I wanted to share. He told me, sir, I'm just in the verge of retirement, just 7 months. if I write on the note that this case is not fit for being filed in the Supreme Court, maybe before I retire, I have a daughter to marry, they will start a vigilance inquiry against me. I thought I will leave it to the court and the wisdom of the judges to decide the case. And so, at least I will not be bothered. I can have a smooth retirement. This is the mentality, and that's how rightly Justice Rohatgi said that we are trying to cut short. Rather, the law officers will take the responsibility to see that the litigations are not filed. Why I had to say all these things? Probably, if these kind of litigation are not filed, probably there would have been a less cost, there would have been a less burden on the exchequer. Probably, we would have had more time to adjudicate on other important matters. Because we know in the Supreme Court on Fridays, we have 60 matters before each bench, out of which we know 40 matters to 45 matters are dismissed. But it's again a debatable point. I had a good case because the judge had a different perception, so he dismissed it. That's a different view. But the fact of the matter is, probably, if we make an introspection, being a stakeholder, if we all decide that we will help in the improvement of the system, probably not only there will be an efficiency in the administration of system, the other factors, including the cost factor, could also be taken note of. With this, I wind up, and I'm prepared to take any question on which, or any other issues on which, whether I have deliberated or I have not spoken. With this, I thank the organizer and the chairman for giving me this opportunity, and also the audience for listening to me with patience. Thank you.
Mr. Shekhar, thank you for your pointed presentation. You have covered a much wider field than the topic indicated. It is natural when the theme of the session is bringing efficiency into judicial administration. It is good that at least you have touched upon it. We are all aware courts are flooded with litigation. Floods are unabated. They are increasing from time to time. But who is responsible for causing these floods? That is the question we all have to think. To my mind, he also mentioned the biggest litigant in the court today is the government. By government, I mean all governments, public undertakings taken together. If there is honesty of administration, efficiency of administration, transparency in administration, you will find many people need not rush to the courts for visit. Public interest litigation is taking a lot of time at the court, highest court and constitutional court, so high courts and Supreme Court. Why public interest litigation? Forget the frivolous PILs filed which deserve to be dismissed with heavy costs. Scam after scam, scam after scam. If lawyers don't take up these issues, who will take up? Who causes the scams? Our representatives are the people. We blame them, but we elect them. Election after election. Who elects them? And ultimately we suffer and we complain. But when the question of voting comes, whom do you vote? There are various issues are involved in this. We are thinking of palliatives. We have to think of tackling the root itself. Coming to palliatives, the way to ease the congestion, quite a few things can be done. We need to shift system in courts. Same judicial machinery can be used for rendering justice in 2 sessions. President Abdul Kalam was very much appreciative of this session. He said, why 2? Have 3 shifts. The media works round the clock. So many factories work like that. And why not we? Second thing, that also helps to reduce the cost of litigation because many advocates who do not have sufficient work now are likely to get more work because a few people in whose hands the work is now concentrated, they cannot afford to burn themselves in both the shifts. Work automatically spreads. The other things can be done. We have been used to adversarial system. Fight to the finish. Till you get the last point you have discovered, till you argue it thoroughly, you won't be satisfied. This must change. The mindset of the bar must change. We must take it as a problem before the court, problem which public interest is involved, judicial time is involved, and try to evolve a non-adversarial system where the judge and the two lawyers appearing representing the parties, all three put their heads together, find a just solution to the problem. In which case, misstatement of facts, misleading arguments, all that will be eliminated. If we bring honesty into our profession also, and a purpose, public interest, things can be resolved. I don't want to cut into your time. Mr. Prashant Kumar is a man of all seasons. He can rise to occasion in any situation, in any contingency, and hold the field. Today, Mr. Aruneshwar Gupta, who was to be here, he was not able to attend. Then Mr. Prashant Kumar has risen to the occasion. Let us hear him. And thereafter, if time permits, we'll have interaction.
Thank you, friends. I don't want to keep you longer between the sumptuous food and all the blah, blah, blah. So once, my topic is information and communication technology, how it can be harnessed to bring more efficiency into justice administration system. But when we talk about technology, let me just say that, I'm coming here again and again to speak. And when we go in the old days of technology, when we used to have only Doordarshan as a channel, the most consistent fixture on TV screen was "Rukawat ke liye khed hai." So I don't want to be counted as one. So just to take from what our chairman has just said about bringing in efficiency, technology is one part. There are several other facets to it as well. And he has pointed about the politicians getting elected. Mr. Ved Marwah also spoke about how in police reforms everything are thwarted by the vested interests. So I think in all the discourse we miss one very big aspect, that we are perhaps one of the only countries which is governed by a single cadre administrative service who do everything. Politicians are temporary executive. Bureaucrats comprising of IAS are the permanent executive, and they are the most resistant bacteria to change. No antibiotics to cure that malady has been invented. And that is where they are the ones who teach the politicians, oh, the money is in this sector, bring this policy, that is how you will make more money. If you want to fix anything, find a joint secretary. He will have his cadre mates and your job will be done. Only the price is to be negotiated. And of course, the minister will be brought in the loop. So, not to digress any further. Information and communication technology to improve justice administration system is already there to an extent. That is that the courts, we as lawyers, we only find the outcome, we get still the paper cause lists and other things. But they are all generated due to a process called case management system, which has been put in place, by which significantly the backlog was reduced and efficiency was brought into the system by bunching of cases, that similar cases with same issues are heard and disposed of by the same bench, so that there is no multiplicity of decisions on the same issue. Then there are others, very small facets which perhaps we don't even pay our full attention to. You find that in the cause list it comes not before so-and-so number, and all. It is all the outcome of the back-end process of technology, which says that perhaps there is an order within the case file, which was passed by the judge who was sitting in one of the stages of the case below, in the lower court, and at the appellate stage, he should be ruled out from hearing it. So all those facets through technology have brought efficiency. Otherwise, all these things used to come to the court only, and you had to point out, oh, this is an order which is passed, and this and this. So these are little functional efficiencies which are already there due to infusion of technology. But then, how to optimize it? Because when briefly I had interacted and I had occasion to be involved with these processes at some level, and Singapore Supreme Court, when it was established, was a completely paper-based court, as most of our courts are here. So it is the state telecom company which had created the system. Then they hived it off, converted into a commercial company called Crimson Logic. And at that time, Chief Justice Kirpal was a little dissatisfied with the government agency which manages the technology aspect in the Supreme Court, that is called NIC, National Informatics Center. So I made the presentation with the Crimson Logic before 5 senior most judges of the Supreme Court, because they said, we don't know how much your judges know, so you have to tailor the technical aspects of the presentation for them to understand. But while doing so, I got involved with the process, and I also learned 2 aspects. One, Singapore was sending its partly state-owned firm to export a technology they had developed. So which means they use technology not only to develop their own systems and bring efficiency, they wanted to earn more by exporting it. The second aspect was that Singapore is a city-state, and the Supreme Court, where the technology was introduced, may not have a docket of 2,000 fresh cases in the entire year. So that being so, a technology fit for our kind of humongous system, where we have such huge case load, it's not a best fit. And another aspect which troubled me was, Crimson Logic had its development office in Bangalore. So it is our own technology engineers who were doing everything. It was just getting routed through Singapore. That said and done, the issue is of vested interest. Again, very innocuous things. We are talking about having Judicial Appointments Commission, a secretariat to serve it, independence of judiciary, various dimensions of it. But again, there are so many crucial aspects which are just sitting there. There has to be a willpower to harness them. Cause list. Now, every single court, and in most of the states right up to the district level, we have generation of cause list. It creates a database or a data bank. Then we have most of the orders in the high courts at least, which every single order, not only the judgments, are coming on the internet. You can download them, that's a facility. But much beyond that, it creates a database. And how crucial and important is that database? Have you ever tried to realize its full potential? Ladies and gentlemen, the same database can be used to show a lawyer whose name you might consider for elevation to high court, how many cases he has argued as a lead counsel. What was the subject and category of these cases? In how many cases he has been persuaded to convince the court and have decided in his favor. All this data exists. Only there has to be a mechanism put in place to harness the data and utilize it for the purpose of cross-checking the credentials of a potential candidate for being elevated as a judge. The same database can be utilized for the purpose of promoting career judges from lower judiciary to the high court. The same database can also be used to elevate high court judges from high court to Supreme Court. How many judgments a particular judge has delivered? What is the frequency of SLPs being filed against his judgments? How many of his judgments have been reversed? And how many areas of law he has dealt with? Don't we think these are very crucial indicators or indices for further strengthening our judicial administration? So we just go the halfway. After that, we don't want to move beyond, because one of the most crucial functions of technology is that it reduces discretion, and nobody wants to give up the discretion. That is the biggest drawback of our system. The other aspect is that no infusion of information and communication technology can be optimized unless until we are creating what we call very user-friendly interface. To develop such interfaces, you should know your user. Apple takes full 1 year to have an upgrade of the product it is offering, or a new product. It takes almost a cycle of 4 to 5 years. And how it is done? The company is world's most successful company because it goes into a very, very intensive research of its users. Now, how can a government department fathom what are the needs, how the legal profession works, how a litigant in person wants to approach the court system works, and to develop the user interfaces which are compatible, which can be put to use? For last 3 years, we have on, or even more, we have daily on our cause lists which are circulated, paper cause lists in Supreme Court. On the last page, e-filing, e-removal of defects. How many of us use that? They have just created a system, never bothered to integrate the user community to even make use of those systems. So it requires a tremendous attitudinal change. It requires a very close collaboration between the user community that is represented by the bar associations and the technology developers. We have not taken any steps to fill these gaps. And the benefits being brought by the technology are tremendous. So that is why one of the things I will like to request, Mr. Shekhar is here, he is the Vice President, he should persuade the Supreme Court to have a joint committee of the Bar Association and the Supreme Court administration headed by a judge. Now we have a judge who had worked, has devoted a considerable time on understanding the ICT and the systems while at being Delhi High Court, Justice Madan Lokur. But somehow, the way the Supreme Court works and other High Court works, it's, very short tenure, Chief Justices and all, there is no leadership direction. And a junior judge is never permitted to have any meaningful participation till perhaps his retirement time comes. So, as I had promised that I will not take much time, we are nearing the lunch. And I will only end it with the thing that what Mr. Shekhar said, that he used to work from 7 to 11 at night, and the juniors demand a lot of money and this thing. Today, the Delhi nightclubs have created special sections for lawyers. And in horse cars, we have clubs which have even the feel and decoration of a lawyer's environment. So that is where we are leading to. But only one thing, 30 seconds. In fact, the cost system is to be reversed. To stop the abuse of court system, in commercial litigation at least, we have to bring in a culture of putting very heavy costs. Anybody who wants adjournment, anybody who is filing a frivolous claim should be put to such heavy costs, and they can put the costs. And once they know they cannot play with the justice administration system for the fear of costs, only then that kind of abuse will be prevented. And the system will be unclogged to an extent. Thank you very much.
Thank you, Mr. Prashant Kumar. Not only you have dealt with the optimizing use of information and communication technology tools in judiciary, but also you have given the latest information about the night clubs and the facilities they provide for lawyers, including environment. This is... Thank you for that. Yeah. Now, friends, we have had 3 very good presentations, studied presentations on 3 different aspects, and